Everyone may sit down. Good morning. It's my first time doing this. I'm Diane Bernholz. I'm going to be the judge. And so, do we have our jury here? And we are, I believe we are ready to go. Is there, I'm not sure if I'm waiting for anything else. We're just ready to go?
I believe so.
Okay. So welcome everybody. Yes, I will be the judge. I believe I sit right here. Like I said, it's my first time doing this, and we're very excited to, honored to be here. So you may proceed.
Yes, Your Honor. Appearances from the government?
Yes. Appearances from the government, please.
Good morning, Your Honor. My name is Varun Aggarawal. I'm with the U.S. Attorney's Office. I'm joined by my co-counsel, Assistant U.S. Attorney Lila Zadell.
Good morning, Your Honor.
Good morning.
Today, we represent the government in U.S. government versus Augie Shepard.
Okay, and appearances from the defense, please.
Yes, Your Honor. Good morning, my name is Sara, Campbell, and I, along with my co-counsel, Ms. Christina Robertson,
Good morning, Your Honor.
represent the defendant in today's case, Augie Shepard.
Good morning.
Good morning.
Okay, so are counsel ready for opening statements?
Before we begin, we have
Yes.
a few housekeeping matters from the government, Your Honor.
Okay.
May we begin by asking Your Honor to constructively swear in all the witnesses that will be testifying in today's trial?
Yes, the witnesses are constructively sworn in.
And we also request the constructive sequestration of all witnesses in this trial.
Yes, that's so ordered.
Your Honor, we'd also like to bring judicial attention to Stipulation 8, which states that both parties have waived all objections to Exhibits 3 through 6. These are reports and affidavits from witnesses that will not be testifying in today's trial.
Okay, the stipulation is received.
And Your Honor, as it's our first time appearing in your courtroom, we'd like to ask your preferences about moving around the well. Specifically, would you like us to ask permission to approach witnesses, opposing counsel, or the bench?
Yes. So when I was at the U.S. Attorney's Office, and that's the way that we did it in federal court, is we would ask for permission to enter the well, because that's typically how they do it in federal court. So yes, I think that that would be appropriate. And typically you would say, Your Honor, may I please approach the witness? That sort of a thing. May I please go into the well? So that is something that's good to do. Yes,
Your Honor. And with that, the government is ready to proceed to opening statements.
Okay, and just the one other rule I would say, which it seems like you're already doing, is every time you speak, if you stand, but it seems that you're already doing that. That was another rule that we always had.
Yes, Your
Yes,
Honor.
Okay, good.
Your Honor, this defense just has one other housekeeping matter, and it's just to make sure that Your Honor has a case packet in front of you that should have all the relevant documents in today's case.
Yes, so I've got a binder here. And yes, I've got exhibits. I do. I believe I have everything here.
Provided that Your Honor has that complete binder, the defense is ready to proceed.
Okay. We are ready, and whenever you would like to begin opening statement.
Yes, Your Honor.
Any other
Permission to enter
matters?
the well?
Or yes, you may. Any other matters that either side has?
None from the government, Your Honor.
None from the defense, Your Honor.
Okay, you may proceed.
May it please the court, members of the jury, follow the tracks. It's June 25th, 2021, and Mr. Augie Shepard, the defendant, is taking a college tour of UCLA with his son. But then, while he's walking around campus, Mr. Shepard sees something he never expected to see. He looks through a nearby window and makes eye contact with a man he hasn't seen in years. You see, members of the jury, you're going to hear today that Mr. Augie Shepard isn't a normal father. He's the head of the Varun crime family, one of the most notorious criminal families in all of Pennsylvania. And the man that he's looking at, his name is Barry Capela. Mr. Capela used to be one member of the Varun family. But that was before he turned traitor and testified against the defendant. So when the defendant looked through that window and saw Mr. Capela, he knew that this was his one chance. And he took it. Because members of the jury, you're going to hear today that less than 24 hours after that, Barry Capela was found dead. If you follow the tracks, you'll see how the defendant committed this crime. That's why today, as the federal government, we've charged the defendant with murder and retaliation against a witness. And what that means is that we have to prove to you that on June 25th, Aggie Shepard killed Barry Capela, that he did so intentionally, and that he did so as an act of revenge because of Capela's testimony. And we're going to prove all of that to you. Because today you're going to hear from U.S. Marshal Connie Wright. Agent Wright is going to walk you through how, if you follow the defendant's tracks, a clear timeline emerges. A timeline that starts with receipts from the moment the defendant made eye contact with the victim. A timeline that goes on to an eyewitness who actually saw the murder. A timeline that moves further to a murder weapon that the defendant had access to. And finally, the actual tracks of the defendant left at the scene of the crime. Because members of the jury, when you follow the tracks, they lead straight to the defendant. So throughout today's trial, we're going to ask you, members of the jury, to follow the defendant's tracks, from the steps of UCLA to the dead body of his former associate, and find the defendant guilty. Thank you.
Thank you, counsel.
Opening from the defense.
Yes, you ready? You may proceed.
Your Honor, opposing counsel, members of the jury, may it please the court. Now, Mr. Aggarawal just told you to follow the tracks. Well, what if I told you that the tracks you need to follow in this case, they're not the defendants, they're the investigators. That you need to follow them step by step in this investigation, and at the end of it, you need to ask yourself, how did we get there? How did we get to a murder trial where Aggie Shepard is the defendant? To understand why the state failed in this investigation, we have to go back to June of 2021. Aggie Shepard is on a college tour with his oldest son. He's beaming with a mix of pride and nostalgia as he hopes he'll have a future Varun in the family. The trip goes perfectly for him. He couldn't imagine that just months later he'd be arrested, ripped from his family, and accused of murdering an old friend. It's a serious allegation. And it's one the state doesn't have proof to back up. A serious allegation without a sufficient investigation. Today, the state has charged the defendant with 2 counts: murder and retaliation against a witness. That means they have to prove beyond a reasonable doubt that Aggie Shepard, a father on a college tour with his son, would drop everything to murder an old friend, and would do so because of 3-year-old testimony. In order to meet that burden, the state needed to have conducted a thorough investigation, one that answers all your reasonable questions. The members of the jury, at the end of today's trial, you'll be left with more questions than you started with. And I want you to pay attention to this one. Did Aggie Shepard have a motive to kill Barry Capela? Did he have access to the weapon that was used to kill him? And did he have opportunity to be at the crime scene? I want to take those step by step, starting with the motive. Because to understand exactly what the state's case hinges on, you have to go back to a trial from 2013. Not in this courtroom, not in this state, in Pennsylvania, where Barry Capela testified against the defendant's nephew. I'll be the first to tell you, it was a hard time for the Shepard family. Aggie felt betrayed. But members of the jury, that was in 2018. By 2021, you'll learn that the defendant had moved on with his life, that he was focused on his child, and that the least of his concerns was 3-year-old testimony from someone he hadn't seen in years. So I want you to ask yourself, would you really drop everything to commit a murder on a family trip with your child because of something that happened years ago? That brings us to our second question. Did he have access to the murder weapon? Because today you're going to hear a lot about a pair of jumper cables that were recovered in this case at the scene of the crime. But members of the jury, what you're not going to hear is any affirmative evidence that proves those jumper cables were ever in my client's possession. You're not going to see any DNA evidence, any forensic evidence that can place those jumper cables in Augie Shepard's hands. So ask yourself, did he have access to the murder weapon? That brings us to our final question. Did he have the opportunity? Because I imagine opposing counsel is going to tell you a lot about a window between midnight and 1 a.m. on June 26th. They're going to tell you that's a time in which this murder must have happened, and that must be the opportunity. My members of the jury, to have the opportunity to commit a crime, you don't just need a time. You need to know where to go. Today you're going to hear the lead investigator in today's case. And she's going to tell you that the victim in this case was in witness protection. That this defendant had no way of figuring out that he was even in California and certainly not where his home was. So ask yourself, how do you have the opportunity to commit a crime when you don't even know where your victim is? Members of the jury, this case comes down to motive, access, and opportunity. Because the state's case didn't start when they walked through those courtroom days. The state's case didn't start when they walked through those courtroom doors. It started the moment that Barry Capela was murdered, and they took an oath to do justice by him, to find answers. But instead, you're going to learn that they jumped the gun. They jumped to conclusions. They make assumptions. And what you have at the end of this case is an investigation that just isn't sufficient. They put a man on trial for murder. It's a serious accusation without a sufficient investigation. That's why at the end of today's trial, I'm going to ask that you find Augie Shepard not guilty. Thank you.
Thank you, counsel. Would the government like to proceed in calling the first witness?
Yes, Your Honor. At this time, the U.S. government calls U.S. Marshal Connie Wright to the stand.
Okay.
Your Honor, permission to approach the well?
Yes, you may. And is the witness sitting here, and am I sitting in the correct place? I want
Yes,
to make
Your
sure
Honor.
that, okay, I'm not sitting where the witness was planning to sit. Okay. So you've already been sworn?
Yes, ma'am.
Okay.
May I proceed?
You may proceed.
Good morning. Can you please introduce yourself to the jury?
Of course, sir, and good morning. I'm U.S. Deputy Marshal Connie Wright.
Agent Wright, how were you involved in this case?
Well, I was the lead investigator in this case. I was also charged with the care of Barry Capela while he was in witness protection.
All right, can you tell us about your educational background and training?
Of course. In 2007, I graduated from UC Santa Barbara with a degree in criminal justice. In 2008, I underwent a lot of federal law enforcement training and joined the U.S. Marshal Service. I've been there ever since.
Do you have a specialization as a U.S. Marshal?
I do, sir. I work in the Witness Protection Program. At the Bureau, we also call it WITSEC. Essentially, my job is to relocate witnesses and informants to ensure that they're safe.
All right, now, Agent Wright, when did you first meet Barry Capela?
I met Mr. Capello in 2018 when he was helping us out with a case.
Why was Mr. Capello in witness protection?
Well, sir, Mr. Capello had told us he'd be willing to trade some testimony he had against the DeBruno crime family, which we'd been tracking for a number of years, in order to waive some criminal prosecution he was facing.
Your Honor, at this time, we're going to be reading out part of an expert report from the FBI onto the record. For stipulation A, all objections have been waived to this report.
On page 2 of the report, lines 33 through 35, testifying against a fellow member is among the greatest sins a member can commit. It is punishable by death, and organized crime families always attempt to impose such a punishment.
Now, Agent Wright, when did you first meet the defendant?
I met Mr. Shepard in person in 2021 when I arrested him.
Your Honor, we're going to be reading another portion of that same exhibit.
On page 2, lines 18 and 19, 2 DeBurno crime family captains have testified under oath that Augie Shepard has been its boss since 2012.
All right, Agent Wright, I want to follow the tracks through your investigation. Do you know when the defendant was in LA?
Yes, sir, I do. I reviewed plane records and phone records of the defendants, and I determined that he arrived in Los Angeles on June 25th of 2021.
Do you know what the defendant was doing during the day on June 25th?
Yes, sir. I interviewed his own son to ensure that I knew what I was doing, and I discovered that the defendant was in Los Angeles to go on a college tour with his son.
Can you tell us what the defendant was doing around noon on June 25th?
Yes, sir. I was actually able to find receipts from the defendant from purchases he made at local restaurants in Los Angeles at around that same time.
Would you recognize those receipts if we showed them to you in court today?
I would, sir.
Could you please flip that binder in front of you open to the document marked Exhibit 15?
Yes, sir. I'm in.
Is that one of those receipts?
Yes, it is, sir.
And Exhibit 16 on the next page, is that also one of those receipts?
Yes, it is from later that day.
Do these appear to be fair and accurate copies?
They are.
Your Honor, at this time, the government moves Exhibits 15 and 16 as evidence.
And,
My apologies. Pursuant to stipulation, I have no objection.
okay, it's received.
Right, now, can you tell us where the defendant was at 12:47?
Yes, sir. That's the first receipt I was able to find here. I discovered that the defendant left an Italian restaurant at 12:47 p.m. on June 25th.
All right, and can you tell us where the defendant was at 12:52?
Yes, sir. That was just 5 minutes later, and I was able to find that the defendant was leaving an ice cream shop just a couple doors down from the restaurant.
Do you know what's between those two restaurants?
Yes, sir, I do. There's a travel agency in between those two businesses called Kline Travel.
And was that relevant to your case today?
It was, sir. You see, in 2018, when I placed Mr. Capello in witness protection, we'd set him up with a new job at Kline Travel with a new identity, Tom Kline.
So do you know if Tom Kline was at Kline Travel that day?
I do, sir. He called me at 12:50 p.m.
And can you tell us about the contents of that call?
Yes, sir. He told me that he had made eye contact with the defendant, with Augie Shepard, and that he was in fear of his life.
All right, now I want to talk about how you followed the defendant's tracks on the night of June 25th. Did you have any witness testimony about where the defendant was that night?
Well, that was part of the problem, sir. You see, when I talked to the defendant's son, Lauren Shepard, he had no idea where his father was that evening, and we had no way to account for his whereabouts at that point.
Did you ever find any evidence that could place the defendant at Barry Capela's house?
I did, sir. I spoke to an eyewitness who saw the attack on Mr. Capello that night.
Objection, Your Honor, to more misleading than probative. May I be heard?
You may be here.
Your Honor, the specific language that I'm objecting to is in opposing counsel's question that places the defendant at the scene of the crime. If I may make an offer of proof?
Yes.
This witness can only testify, as it relates to this eyewitness, that this eyewitness saw someone from behind, a generic description that they couldn't affirmatively identify as the defendant when this interaction happened. To say, do you have any affirmative evidence placing the defendant at the scene of the crime, and to use this eyewitness is substantially more misleading than it is probative.
Response, Your Honor?
Yes.
First of all, to be excluded under Rule 403, it has to be substantially more misleading than it is probative. In this case, the probative value, if I may proffer, Your Honor, if I may proffer.
Yeah,
the
you may
testimony.
proffer. And by the way, this would be a sidebar, which obviously we're not going to do as a sidebar, I was told, so everyone can hear. Yes.
Yes, Your Honor. The testimony is going to be that someone that matches the defendant's profile was seen murdering the victim. Now, we're not saying that this was the defendant, or at least this witness won't testify to that, But to ask if there was any evidence placing the defendant at the scene of the crime is certainly not substantially more misleading than it is probative when a witness saw someone that looked like the defendant committing the crime.
Your Honor, may I be heard on those grounds?
Yes.
I agree with opposing counsel, but saying the defendant and someone who looked like the defendant is actually a pretty important distinction in trial today. To say that you saw someone from behind with a similar build is very different than saying I identified the defendant at the scene of the crime and that's what I'm objecting to. I think that language is substantially more misleading than it is probative pursuant to a rule.
Okay, so repeat, I want to hear the question that you asked again, please.
Yes, Your Honor. The question was, did you find any evidence that could place the defendant at Barry Capela's house on the night of June 25th?
Okay, so I'm going to rule that I'm going to mostly agree with the defense attorney here because I think a more proper way to do it would just be to ask something like, can you describe any further investigation you did as to events that happened that evening or something like that? Do you understand?
Yes, Your Honor.
Yeah, so I will sustain that.
Yes, Your Honor.
Yeah.
Agent Wright, did you have any eyewitnesses that told you about the murder itself?
Yes, sir. Across the street from Mr. Capello's house, a neighbor named Bellamy Dembski reported to the U.S. Marshal Service that he saw the attack.
Can you tell us what Mr. Dembski told you about the attack?
Certainly, sir. Mr. Dembski informed us that he saw the attack and that he saw the attacker's build and height. He told us that the attacker was 5'11" and athletic. He also told us the attacker was white and had black hair.
And did Mr. Dembski tell you what weapon the murderer used?
Mr. Dembski told us that the attacker was holding some sort of blunt object, grabbing Mr. Capello from behind, and that immediately after Mr. Capello fell to the ground, the weapon in the attacker's hands dropped. And the attacker left it there and fled the scene.
Did you ever recover that weapon?
Yes, sir, I did. It was a pair of jumper cables, like you would use to start a car.
Now, would you be able to identify those cables if I were to show them to you in court today?
Certainly I would, sir.
Permission to approach the witness?
You have permission.
Are these those cables?
The exact ones, sir.
Have they been changed in any way?
No.
Your Honor, this time the government moves Exhibit 25 into evidence.
Is there any objection?
Without objection, Your Honor.
Case received.
All right, now, Agent Wright, were you able to figure out if the defendant had access to a similar pair of jumper cables?
Yes, I was, sir.
And how were you able to do that?
Well, I subpoenaed the car rental service that the defendant had used while he was in Los Angeles. The defendant had been renting a green Ferrari, and the company usually provides the same exact make, size, and model of those jumper cables inside the trunks of their cars.
Now, you just told us a minute ago that Mr. Dembski told you that the attacker was 5'11", 180 pounds, and had black hair. Does that match a description of the defendant?
Every descriptor that Mr. Dembski gave us matched the defendant, sir, yes.
Now, did you ever find any other evidence at Barry Capela's residence?
I did, sir. We searched for forensic evidence and found 4 footprints near Mr. Capello's body.
Now, what can you tell us about those tracks?
Well, obviously, sir, we sent them to our forensic lab for analysis. When we did, we learned information that the size was 11, men's shoe, and made by someone who was approximately 5'10" and in between 170 and 190 pounds.
Now, were there any similarities between the tracks at the scene of the crime and the defendant?
Yes, sir. Once again, they matched in every way. The defendant's shoe size was the same size of the print we found at the scene. His height was the same, and his build matched as well.
Thank you. Your Honor, we have no further questions for this witness.
Okay. Thank you. Any cross-examination?
Yes, Your Honor. May I proceed?
Yes.
Good morning, Deputy Marshal.
Morning, ma'am.
Now, I want to start with something you mentioned on direct examination. Because you talked a lot about the eyewitness testimony of someone named Bellamy Dembski. Is that right?
That's correct, ma'am, the neighbor.
And you made it sound like Mr. Dembski was pretty certain about what he saw on the night of the murder. Is that right?
He gave us a lot of details, yes.
But to be clear, in Mr. Dembski's own words, he wasn't so certain about what he saw, right?
That's not quite true, ma'am.
Well, isn't it true that Mr. Dembski said he thought perhaps the attacker was white, but he only saw the back of his neck and couldn't be sure, right?
Yes, ma'am.
He said that he thought maybe his hair was black, but it was dark outside, so he couldn't really tell, right?
Yes, ma'am, though both of those facts were corroborated through photographs.
And so that's a yes to my question. The eyewitness that you relied upon didn't give you a straight answer about what exactly they saw on the night of the murder.
No, ma'am, he gave us a straight answer. He just said he wasn't 100% certain because it was dark outside.
So that's a yes to my question. He wasn't exactly certain.
On those specific facts, yes.
But he wasn't certain about a number of other things. Isn't that true?
Which ones are you referring to?
He couldn't identify that the car the assailant arrived in, right?
That's not true, ma'am. He told us it was a dark sports car matching the description of the defendant's car.
To be clear, he couldn't give you the make.
He told us it was a Ferrari or a Lamborghini.
So he told you it was a Ferrari or a Lamborghini or a Maserati. That's not the exact make, is that right?
It's a similar make, ma'am. The defendant was driving a Ferrari.
So bringing you back to my question, your eyewitness couldn't provide the exact make. Is that a yes?
Other than telling us it was perhaps a Ferrari, no.
He also couldn't exactly give you the color of that car, right?
That's correct, ma'am, just that it was dark.
And everything you say that this eyewitness saw, it was from across the street, right?
Yes, ma'am, that's true. They lived directly across from one another.
The nearest lights were about 25 feet away.
The nearest lights from the car the witness was viewing, the garage lights of the house also came on, as well as the trunk of the victim's car.
So besides the one light on the victim's house, the nearest street lights were about 25 feet away from the car that this person saw.
There were 2 lights on the garage, 2 lights in the street, and the light from the trunk of the car.
And those lights were a reasonable distance away, right?
Sure.
So I want to talk about how you would characterize your own investigation. Because you say your investigation was thorough and complete, is that right?
That's right, ma'am.
You said that you only omitted steps in your investigation that didn't yield any evidence.
Well, I didn't omit steps in the investigation. I didn't write them in the report for brevity.
So in your report, you didn't include any steps in your investigation that you didn't think yielded any evidence.
That's right, ma'am.
So in your report, you never mentioned searching for DNA at the scene of the crime, did you?
We did search for DNA, ma'am, but we didn't find any.
So bringing you back to my question, is it your testimony that in your report, you say that you searched for DNA at the scene of the crime?
No, ma'am, I clarified that any investigative step I took that yielded no evidence wasn't in the report.
So I want to talk about some steps you took you either didn't really look for or didn't yield any evidence. Because in your report, you say that you never really found any GPS evidence to indicate where the defendant's car was on the night of the murder, right?
The Ferrari the defendant was driving did not have GPS data when we searched it. That is correct.
So, according to your report, if you looked for it, we wouldn't really know, right?
We did look for it, ma'am. That was in the FBI agent's report.
So to be clear for the members of the jury, the reason that you didn't provide any evidence about that GPS data is because you didn't find any.
I didn't provide the evidence, ma'am, because it didn't exist, though we, of course, looked.
Exactly. There was no evidence to suggest that my client's car was at the scene of the crime on the night of the murder. Is that right?
No GPS evidence, ma'am, just the eyewitness.
So I want to talk about something else you didn't quite look into. Because in your report, you never mentioned going to the scene of the crime yourself until around 1:32 in the morning. Is that right?
That's not correct, ma'am. I arrived at 2:14 on the morning of June 26, 2021.
My apologies. You weren't contacted until around 1:32 in the morning.
That's true by the victim's wife.
And you didn't identify any other eyewitnesses who could place the defendant at the scene of the crime except for Bellamy Dempsey, right?
That's right, ma'am. The murder occurred in between midnight and 1 a.m. The only eyewitness we found was the neighbor.
I want to talk about something else you didn't quite look for. Because you know that in order for the defendant to have gotten to the scene of the crime, they would have to drive from their hotel to the victim's house, right?
Presumably, ma'am.
That's a number of miles, right?
7.2 to be exact.
And nowhere in your report do you say that you checked security camera footage along that route, did you?
I did check for security camera footage, ma'am.
So you're telling the members of the jury that you checked, but you didn't include it in your report.
It yielded no evidence.
Exactly. No security camera footage yielded any evidence that showed my client leaving their house to the scene of the crime.
The hotel, ma'am, yes.
So I want to talk about why we're here today. Because you'd agree when I say that it's important for investigations to be thorough, right?
Of course it is.
To be unbiased.
Yes, ma'am.
For investigators not to jump to conclusions.
That's true.
But that's not exactly what happened in this case, is it?
It is, ma'am.
Well, then I want to talk about that same eyewitness, Bellamy Dempsey, because that's the only eyewitness that you had in this case, right?
Yes, ma'am. We searched and he was the only eyewitness who saw anything.
And when you talked to Mr. Dempsey, investigators showed him a picture of the defendant and a number of other people, right?
The local detectives did, ma'am, when he was initially questioned shortly after the crime, yes.
And so those local investigators showed Mr. Dempsey a picture of the defendant, and he said, I don't recognize anyone in this photo except for the victim, right?
That's not true, ma'am. He identified your client as the attacker of Mr. Capela.
We'll get to that in a moment, Deputy Marshal. I'm asking, when first asked if he recognized anyone in this photo, he said, no, I don't, besides the victim.
That's true, ma'am.
It was only after investigators in this case demanded he took a second look that he ever identified my client as the assailant in this case.
Yes, ma'am. During the normal process of questioning, the witness remembered that he saw the defendant on the night of the crime and reported that to the police.
You said the normal process of questioning, but I want to be clear about what the question was. The question was, is that the man that you saw commit the murder? Pointing to my client, right?
Nobody pointed to your client physically, ma'am.
Singled out my client and asked, is that the man you saw?
Yes, ma'am.
Now, the picture that they were shown, it was a front view, right?
Yes, ma'am, of Mr. Capela, the victim, and the defendant.
It showed the defendant's face from the front, right?
Yes, it did.
But on the night of the murder, Mr. Dempsey actually never saw the face of the assailant, right?
That's true, ma'am. He reported that during most of the attack, the attacker was facing away from him, and that he caught views of the back of the attacker's neck, his clothes, his build, things like that.
Exactly. So he never actually saw the assailant's face, right?
That's true, ma'am. Just other details about his physicality.
But the picture your investigators used to identify the defendant was a front view. Is that right?
Yes, ma'am, but it also showed the defendant's hair, his skin color, his build, his height, other details that Mr. Dempsey were able to confirm.
And it was only after being gestured to by your... My apologies, Your Honor. If I may finish my last question.
You may finish that question.
It was only after being singled out by your detectives that Bellamy Dempsey ever identified the defendant as the assailant in this case.
Yes, ma'am, the defendant was identified as the assailant.
Thank you, Your Honor. I have nothing further.
Is there redirect?
No redirect, Your Honor. We just asked the witness to be excused.
Okay. Thank you very much.
Thank you.
Your Honor, with that, the government rests our case in chief.
Okay. And so, does the defense wish to call any witnesses?
Yes, Your Honor. The defense calls Lauren Shepard.
Just remind the witness, you are under oath.
Yes.
Thank you. And you may proceed.
Good morning. Could you please introduce yourself to the members of the jury?
Good morning. My name is Lauren Shepard.
And what brings you to court today, Mr. Shepard?
I'm here because I know my father, Augie Shepard, is on trial for murder.
Before we talk more about your relationship with your father, I want to talk about your relationship with the victim in this case, Barry Capela.
Sure.
How did you know him?
Barry was a family friend. We call him Uncle Barry. He'd come over for cookouts, garden parties, dinners, stuff like that. We were all close with him.
And I want to make something very clear for the members of the jury. On June 25th, did you ever hear your father threaten Barry Capela?
No.
Did you ever hear your father mention Barry Capela?
No.
Then I want to talk about why we're here today and what you were doing in LA. What brought you to LA during June?
I was touring for colleges. We were making a big run up the West Coast. At that point, we were touring UCLA.
And what date were you touring UCLA?
That was June 25th of last year, so it would have been 2021.
Can you explain to the members of the jury what your schedule for the day was?
Yeah, sure. So we were just coming from another college, so we went to the hotel, checked in, had some meals during the day, came in and out of the hotel, had our tour, stuff like that.
You mentioned you had some meals during the day. Around what time did you get your first meal?
I think, so we got in after 10, so I think our first meal would have been lunch. We went to this Italian place at noon.
I want to be very clear. Was your dad the one who recommended you go to that Italian restaurant?
No, I made the reservation.
Did your dad ever indicate that he knew any of the businesses surrounding that restaurant?
No, you didn't say anything about that.
Where did you go after lunch?
Well, I was still a little bit hungry, so we just walked right down the street and grabbed some ice cream.
How far was the ice cream shop from the restaurant where you had lunch?
Couldn't have been more than a couple minutes.
Were there any businesses in between?
Yeah, I think there was one that looked like some travel agency.
When you walked past that travel agency, did you ever see your dad look inside?
I don't think so, no.
When you walked past that travel agency, did you ever see your dad say he saw someone he knew?
No, neither of us said anything about it.
When you walked past the travel agency, did your dad ever say he saw Barry Capela?
No?
And then I want to move to later in the evening.
Okay.
What'd you do after you had lunch in your tour?
So after the tour, I think we just wanted to rest for a little bit before dinner, so we went back to the hotel for a few hours.
And when you were at the hotel, how would you describe your father's demeanor?
He was normal. I didn't notice anything about him.
After getting lunch and passing that travel agency, did you notice any unusual behavior?
No, we were just hanging out. He just seemed like my dad.
At that point, had your dad even mentioned the name Barry Capela?
No.
You just said that you went back to the hotel and got ready for dinner. Around what time was dinner?
I think we left like 7:30, would have got there around 8.
And how long were you having dinner?
A couple hours, probably got back close to 10.
Between lunch at noon and when you came back from dinner at 10, were you with your dad the whole time?
Yeah, we were there together. We were grabbing dinner.
In that entire 10-hour period, did you see any unusual behavior from your father?
No, everything just seemed normal.
What did you do after you came back to the hotel?
So I think my dad went to sleep and I went to a party.
Did you tell the police that you went to a party that night?
Not exactly, not at first.
And why didn't you tell the police when you were asked that you went to a party that night?
Look, I'm under 21. I wasn't supposed to be going to that party in the first place. I didn't want my dad to find out and be disappointed in me. I know it was the wrong thing to do, but that's what happened.
You can tell the members of the jury about how long you were at that party.
So I left around 11:30 and I got back around 3 a.m.
And between when you left, what was your dad doing?
I mean, when I left, he was sleeping.
When you came back, was your dad still sleeping?
Looked like it. I mean, he was in bed, lights off. He was sleeping.
Now I want to move to the next morning, the morning of June 26th.
Okay.
When you saw your dad that morning, did he have any bruises on his hands?
No,
Did he have any injuries on his hands?
not that I could see.
Any visible new cuts or bruises?
No, it did look like he had just slept.
Did he mention any injuries to you?
No.
Then I want to talk about why we're here.
Okay.
Now, throughout this investigation, from last June to this June, have the police ever questioned you again after that first initial time?
No, that's the only time anyone ever spoke to me.
They ask you any additional questions about what you might have seen on the night that Barry Capela was murdered?
No, it was just the one interview with that marshal.
Did they ask you any additional questions about where your father might have been?
No.
And I want to be very clear for the members of the jury. Throughout the entire time you were in office, did you ever hear your father threaten Barry Capela?
No.
Did you ever hear him insult him?
No, I didn't hear anything like that.
Did he ever indicate he knew where he lived?
No.
Did he ever indicate he was planning on harming Barry Capela?
No, my dad didn't say anything like that.
Thank you, Mr. Shepard. Your Honor, I have nothing further, but at this time we'll be reading from a portion of the forensic report.
Okay.
Exhibit 7. My apologies, Your Honor. A moment of the court's indulgence.
No problem. Which exhibit?
7.
Okay.
My apologies, Your Honor. I think it might be 6.
That's okay.
I'll be reading from the second page of Exhibit 4, actually. Again, my apologies. From lines 8 to 16.
Okay.
This is from the forensic report used in this case. Obtained warrant for Augie Shepard's iPhone and all data associated with phone. No text messages on phone for any time period. Checked call log from 1900 hours on June 25th to 0400 hours on June 26th. Phone received 1 call from wife Carmilla Shepard beginning at 1903 on June 25th, lasting 3 minutes. Phone made 1 call to wife Carmilla beginning at 17:45 on June 25th, lasting 4 minutes. Location data places the phone at UCLA guest house from 22:15 hours on June 25th to 0500 hours on June 26th. Location data shows earlier movement to Pomodoro Trattoria, UCLA campus, Maestro Steakhouse, and UCLA guest house. Is that, Your Honor? I got that correct.
Okay. Does the government have cross-examination?
Yes, Your Honor. Permission to
Okay.
enter the well?
Yes, you may.
May I proceed?
Yes, you may.
Good morning, Mr. Shepard. I'm just going to be asking you a few questions about what you just said on your direct examination.
Sure. Good
So,
morning.
first I want to talk about what your dad does for a living. According to you, he is in waste management, is that correct?
Yeah, that's what my dad always told me.
Well, you'd say that you actually live a pretty comfortable life with your dad, is that right?
Yeah, he owns his own business.
You have a 6,000 square foot house in a gated community.
That's right.
Your father drives a Suburban.
He does.
Your mom drives a Porsche.
Yes,
You actually received a brand new Mercedes for your 16th birthday.
I did. I thought it was too much.
And your little brother received the same for his 16th birthday.
He did.
Now, your father owns his own yacht.
Yeah.
To be clear, you still say that even after all of that, he only does waste management?
Objection, Your Honor. Asked and answered.
Response, Your Honor?
Yes. Yeah, you may respond.
Your Honor, given all of that context, the question hasn't actually been properly answered. I'm giving this one more chance to tell the truth about whether or not his father is in the mob or not.
Your Honor, may I be heard?
Yes.
The specific question that opposing counsel asked is, you say your dad is still just in waste management, and that was the question that he started this pocket with. You say that your dad only works in waste management. It's asked and answered at this.
Response, Your Honor? Briefly.
Yes.
Your Honor, the question was, your dad is just in waste management. We don't contend that he owns a waste management facility. The question is there anything else he does to make all that money? That's a different question.
I'm going to allow it. I'm going to allow it.
Yes, Your Honor.
So based on all of that, you still say your dad is just in waste management?
Yeah, it's like I said, he runs his own business. He does well for himself.
But he doesn't really tell you anything about that business, does he?
No, it sounds like he likes to keep, work and family separate.
That's right, your dad keeps work and family separate.
Yeah, that's what it seems.
All right, now I want to talk about your relationship with Barry Capela, because you knew Barry a couple years ago, is that correct?
Yeah, that's right. He was a good family friend.
Barry Capela worked with your dad?
Yeah.
Your dad was actually pretty close with Barry Capela.
Yeah, it seemed like they were really good friends.
You called Barry Uncle Barry.
Yeah, he'd come over a lot.
That's right, he was over at every holiday.
Yeah,
But that all ended in 2018.
that's right. That's when the trial happened.
That's right. Barry Capela testified against your dad.
Objection, Your Honor, to lack of foundation. May I be heard?
You may be heard.
We haven't heard any foundation on the record at this point to substantiate how this witness would know exactly when this trial happened and exactly what kind of exchanges happened during it. Until that foundation has been laid, I believe that question should be stricken from the record.
Response, Your Honor?
Yes.
This witness actually just said in the previous answer, yes, that was when the trial started. It's clear he has personal knowledge of that trial.
Your Honor, may I be heard?
Yes.
While this witness testified that he has personal knowledge that a trial was happening in 2018, to ask about specific contents about what happened in that trial, we have to hear foundation for how he would know exactly what happened.
Your Honor, may I clarify?
Yes, but I am going to make a suggestion. It probably will not hurt your case at all to get a little more foundation typically it's helpful for the jury perhaps to hear a little more foundation, so I can rule on it, or you may just want to ask a couple foundation questions?
Yes, Your Honor, I can lay
Yeah.
that foundation.
Yeah.
All right, now, you're aware that there was a trial of your cousin in 2018.
Yeah, that's when Enrico was going on trial.
In that trial, Barry Capela was a witness.
That's what my dad told me.
Your dad told you about the testimony that Barry Capela gave.
Yeah, he mentioned some of it.
And your dad told you that Barry Capela testified against him.
That's not exactly what he said.
Your dad didn't say that Barry Capela testified against him?
No, he was testifying against my cousin Enrico.
But I just want to be very clear here. According to your father, in that trial, Barry Capela named Augie Shepard as the head of the DeBruno crime family.
That's what my dad said Uncle Barry was saying. I don't know where he got that from.
That's right. So in his testimony, Uncle Barry testified against your father.
No, he was testifying against Enrico. He mentioned my dad, I think, but I don't think he was testifying against my father.
Right, but to be clear, in that testimony, Uncle Barry implicated your father as the leader of the DeBruno crime family.
Yeah, that's what my dad told me.
Now, after that testimony, your dad actually called your Uncle Barry a rat.
Yeah, that's what my dad said.
Your dad said that Uncle Barry is dead to our family.
That's what he said.
Now, Mr. Shepard, you're aware that Uncle Barry is actually dead now, right?
Yeah, I understand that's kind of why we're all here.
All right, now I want to talk about where you were on June 25th.
Okay.
You remember getting dinner or lunch at a restaurant called Pomodoro?
Yeah, it was Italian food.
And you mentioned on direct that right after you walked to get some ice cream after.
Yeah, right down the street.
Now, your dad was with you the whole time.
He was.
And you left that restaurant at 12:47 p.m. Is that correct?
Yeah, that sounds right.
You got to the ice cream shop at around 12:52 p.m.
Yeah, it couldn't have been more than a couple minutes away, so I think, yeah, that makes sense.
So in the couple of minutes between 12:47 and 12:52, you were walking between those two restaurants.
Yeah.
Now, you've been shown a map of what's between those two restaurants.
Yeah, that's one of the things that the marshal showed me.
And you're aware that you and your father passed an agency called Kline Travel on the way between those two restaurants.
Yeah, it was that travel agency I mentioned.
So just to be clear, you and your father passed Kline Travel between 12:47 p.m. and 12:52 p.m. on June 25th.
Yeah.
All right, now later that day, you were at the UCLA guest house.
Yeah, that was the hotel we were staying at.
And before dinner, you stayed there for about 3 hours. Is that correct?
I think it would have been somewhere in the range of like 5 and 8.
That's right. You stayed there from 5 p.m. to 8 p.m.
Yeah, that sounds right.
And you were on your computer with your headphones on.
Yes.
And you would say that your father was on the phone the whole time.
Yeah, that's what it looked like. He had his phone with him.
Right, he was making a phone call the whole time.
That's what it seemed like to me.
I just want to be clear here for the members of the jury. You'd agree that 3 hours is a lot longer than 4 minutes.
Yeah.
But you're still saying that your father was on the phone the whole time, from 5 p.m. to 8 p.m.
Well, I had my headphones in, so I didn't hear exactly what was going on, but it looked like he was on the phone.
All right, now I want to talk about how you tried to cover up your father's tracks. You remember being investigated by a U.S. Marshal, correct?
Investigated?
You were interviewed by a U.S. Marshal.
Yeah, that marshal talked to me.
The Marshal asked you about where you were on June 25th.
He did.
And at first, you told the Marshal that you were in your hotel room all night long.
That's right. That wasn't the truth.
That's right. You lied directly to that U.S. Marshal.
I did. I wasn't supposed to be at that party. I know it was wrong, but that's what happened.
It wasn't until after the Marshal confronted you with your phone records that you mentioned that you actually left the hotel at 11:30.
That's right.
And you told the Marshal that you came back at 12:30.
That's right. That also wasn't true.
That's right. You lied to the Marshal again.
Yeah, I was frankly embarrassed that I was out that late. It was a long night.
So it wasn't until the Marshal confronted you with your Uber records that you finally changed your story and said you came back at 3 a.m.
That's right.
So I want to be clear here. You were not with your father from 11:30 p.m. to 3 a.m. on the night of June 25th.
I wasn't.
And when first asked about that, You lied about that fact to a U.S. Marshal.
That's right, like I said.
Thank you. Your Honor, we have no further questions for this witness.
Okay, any redirect?
Yes, briefly, Your Honor. May I proceed?
Yes.
On cross-examination, you were asked why you lied to the U.S. Did it have anything to do with trying to cover your father's tracks?
No, like I said, I was under 21. I wasn't supposed to be out that late at that party. I didn't want to disappoint my family.
Before you went out to that party between 11:30 and 3, had you heard any indication that your father was planning on harming anyone?
No, he didn't say anything about that.
Had you heard any indication that your father was planning on harming Barry Capela?
No, he didn't even say the name.
Thank you. Your Honor, I have nothing further.
Any recross?
No recross, Your Honor.
Okay, so we're all done with the witness?
Yes, Your Honor.
Thank you very much. You may be excused.
Thank you.
Okay. And so, does the defense have anything else?
No, Your Honor, with that, the defense rests its case in chief.
Okay. Is there a rebuttal case at all, or there's no rebuttal in this case?
Not in this jurisdiction, Your Honor. At
Okay.
this time, the government is ready to proceed to closing arguments.
Okay, so you go right to closing, no break? Okay.
Yes, Your Honor.
You may proceed.
May I enter the well?
Yes, you may.
May it please the court. Members of the jury, follow the tracks. Throughout today's whole trial, we've been following the defendant's tracks on the night of June 25th. We followed the defendant from the halls of UCLA all the way to Barry Capela's house, and then back to his residence in Pennsylvania. So now that we've heard all the evidence, we've seen all the witnesses, and we know all of the facts, let's follow the defendant's tracks one last time and see exactly how he murdered Barry Capela on the night of June 25th. Because members of the jury, today you heard from U.S. Marshal Connie Wright. And Agent Wright walked you through every single step the defendant took on June 25th. How the defendant made eye contact with Barry Capela, someone they hadn't seen in years, at around noon that day. And from there, the plan was set in motion. Because members of the jury, today you heard that when a crime family like the DeBrunos sees someone that testified against them, well, they don't have a choice. They will always enact the punishment of death for that testimony. Now the defense is going to come up here and tell you that it was 3 years ago. How could that possibly matter? Members of the jury, it was only 3 years ago that Barry Capela testified against the DeBruno crime family. And at the very first opportunity, its boss, Augie Shepard, chose to take its life. Because those receipts put Augie Shepard exactly outside the place where the victim was, at exactly the same time that the victim claims to have seen Augie Shepard. And you heard from Marshal Wright today. At 12:50, they received a call from Augie Shepard. Sorry, my apologies, from the victim. Augie Shepard is outside my place of business. We just made eye contact. I'm scared for my life. Barry Capela was dead less than 24 hours after saying those words. So if we keep on following the defendant's tracks, it becomes clear what happened after that. The defendant saw Barry Capela and made a plan. And that evening, he was preparing for the mission he had that night. Because he heard today about some data taken from Augie Shepard's phone. That phone data shows a couple interesting things. It tells us that Augie Shepard only made 2 calls the entire day on his official phone that he has listed with the government. And neither of those calls was more than 4 minutes long. But you heard from Augie Shepard's child today that he was on the phone for 3 hours that night, So what does that tell us, members of the jury? It tells us that Augie Shepard had a second phone, that it was never turned over to the government, and that it must have been used for illicit purposes. Because Augie Shepard was on the phone for 3 hours that night. His child didn't hear anything about that phone call, but we know the aftermath. Because right after that phone call, Augie Shepard went out to dinner, came back, and then left his hotel room. You see, early on, in the hours of the night, Lauren Shepard left the house. And that was when Augie knew he had his chance. So he got into his dark green sports car, drove over to Barry Capela's house, and used these jumper cables to strangle Barry Capela to death. You heard all of that through the eyewitness testimony of Bellamy Dembski. How a man, 180 pounds, 5'11", with black hair, was seen using those jumper cables to strangle the victim to death. You heard from Marshall Wright that there were tracks left at the scene of the crime from a man weighing 180 pounds, standing exactly where the murderer was. Members of the jury, if we follow those tracks, they lead right back to the defendant. Members of the jury, we've been following those tracks throughout this entire trial, and we've been following those tracks throughout this entire investigation. You've heard all the evidence. You've listened to all the witnesses. So now all that's left is to get justice for Barry Capela. As the defense said in their opening statement, we had to prove to you, beyond a reasonable doubt, that the defendant is guilty of murder and retaliation against a witness. Now that we've heard all the testimony, I want to be very clear. Beyond a reasonable doubt doesn't mean beyond all doubt. What it means is that there is only one reasonable explanation for why Barry Capela was dead. Members of the jury, from following the defendant's tracks, it is clear there is only one reasonable explanation. That on the night of June 25th, Augie Shepard strangled Barry Capela to death with jumper cables from his car as revenge for the testimony against the DeBruno crime family. And that's why we're asking you to find the defendant guilty. Thank you.
Thank you, counsel. Is the defense ready?
Yes, Your Honor. May I proceed?
Yes, you may.
Your Honor, opposing counsel, members of the jury, may it please the court. Throughout trial today, you've heard some serious accusations. You've heard about a father who'd apparently be willing to put himself and his child in danger to get back at someone he hadn't seen for years. A father that the moment he made eye contact with someone would drop everything. Plan a murder, go get ice cream, get dinner, and then go kill somebody? Members of the jury, opposing counsel just told you there needs to be one reasonable explanation. So ask yourself, is that reasonable? Opposing counsel asked you to follow the tracks, well, I'm asking you to follow the facts. Because fact, Augie Shepard was at his hotel for the entire window in which opposing counsel says this murder must have happened. His cell phone data shows that from 10 p.m. to 5 a.m. He's exactly where he said he was, at the UCLA guest house, asleep, waiting for his son to come back. Fact. There is no DNA evidence that you heard in trial today linking these jumper cables to Augie Shepard. Members of the jury, ask yourself, did you see any fingerprints? Did you hear about any skin cells? Did you hear about any clothing fibers? Anything that would indicate that these jumper cables were ever in my client's hand? So I want to ask you about how he had the opportunity. Because the state's own witness told you today, the victim in this case was in witness protection. That it was in fact the state's job to make this person untraceable enough. That no one should have been able to find him, especially someone he just saw in passing. So members of the jury, ask yourself, is it reasonable to assume that just off a chance encounter passing a travel agency, he was able to find where Barry Capela lived in witness protection? The state told you today they had access to all of the defendant's cell phone data. They didn't find him Googling addresses, Googling Barry Capela, Googling the name Tom Kline or where he worked. Opposing counsel just tried to tell you it's because of a burner phone. Members of the jury, if opposing counsel is raising new questions about what exactly happened in this case in their summation, tells you everything you need to know about this investigation. A serious accusation without a sufficient investigation. Because today when the state came to court, they assumed the burden of proof. They had to prove to you beyond a reasonable doubt that Augie Shepard murdered an old friend just because he saw him in passing. That calling someone a rat in 2017 means in 2021 you want them to. That's a heavy burden. The highest in our criminal justice system, and it rests solely on that case. As a defense, we had no burden. We didn't have to prove who killed Barry Capela or how it happened. That was the state's job. They had to give you answers to all of your reasonable questions. So I want to talk about 3 reasonable questions. Did Augie Shepard have motive? Did he have access to the murder weapon? And did he have the opportunity to do it? I want to take us back again to 2018. A hard time for the Shepard family, a nephew going away to prison, but members of the jury. It wasn't worth murdering someone. In fact, you heard no direct evidence today that Augie Shepard was a mob boss or a murderer or someone who would interrupt their family trip to get vengeance on someone they hadn't seen for years. Someone their kids called Uncle Barry, someone they trusted in their life. So let's talk about access to the weapon. Because they told you that these jumbo cables must have been in the defendant's rental car. But what they didn't tell you, members of the jury, well, you'll see when you go back to that jury deliberation room, is that these cables could have been missing from the defendant's car for months before he ever rented it. That 3 people rented that same car after the defendant did, and that any single one of them could remove these cables before or after Barry Capela died. Without DNA, without forensic evidence, this isn't the smoking gun opposing counsel would have you believe this. So that brings us to the opportunity. Because members of the jury on cross-examination, the state's own witness told you today, they have no evidence to suggest that the defendant drove his car from his hotel to where the crime happened. No evidence placing him at the scene definitively, except a shaky eyewitness identification at best. Members of the jury, describing a 5'11" white man from behind could be any number of people. To say that seeing someone who's 5'11" with black hair from behind means that my client must be guilty of murder, it's not just a stretch. It's not just a leap. It's not just an assumption. It's unreasonable. So I want to remind you of their book, Beyond a Reasonable Doubt. They made a serious accusation without a sufficient investigation. Find him not guilty. Thank you.
Your
Thank you,
Honor, at this
counsel.
time, the government raised an objection to facts not in evidence to the defense's closing. May I explain?
Yes, you may be heard.
Your Honor, in closing arguments a few moments ago, the defense just raised the issue of how in evidence there is evidence of 3 people renting the car after the defendant did. That did not show up on the transcript of the record at any point. It's contained in a document the defense attempted to enter into evidence earlier before this trial, but was never entered in this trial. Therefore, is not in evidence and cannot be talked about on closing arguments.
Your Honor, may I be heard?
Yes.
The document to which opposing counsel is referencing, I believe that it's Exhibit 16, is the same document that their own witness referred to on her direct examination to establish exactly how they knew what car the defendant had been driving and to identify, oh, my apologies, Your Honor, the page cut off, and I believe it's Exhibit 10.
All right, Court needs just a moment to
Yes, Your
find
Honor.
this exhibit, please. Unfortunately, there are no tabs, so it takes me a little while to find exhibits. All right, so
The tab may be cut off in my printed version.
I know, I wish there were
It's not.
tabs on the side, I could find things a lot easier. I've got Exhibit 8, just give me one moment, please, Exhibit 9.
Yes, Your Honor.
Okay, Exhibit 10. Okay, so now I'm looking at that.
Your Honor, if you look at Exhibit 10, you'll see that this is a letter from the rental agency confirming exactly what car the defendant drove, and that jumper cables were supposed to be in the back of that car when it was rented. Your Honor, we heard from the state today that one of their main points was that jumper cables missing from the defendant's car means that he must be guilty from this crime, and that information comes from this document itself.
But where, let's see.
At the
It has
last
been
time.
rented to 2 other individuals and professionally cleaned 3 times. All right, let me just see this. So however, we should be clear that since Mr. Shepard, since he returned the vehicle, it has been rented to 2 other individuals and cleaned 3 times. All right, so now let me hear again from, now you said it was rented 3 times after? Is that what you had said? Because it sounds like according to this, it was 2 times.
My apologies, Your Honor. I may have been mistaken, but my response to the objection was more on the grounds that this document itself was the foundation of the state's testimony earlier in today's trial.
Okay, I'm going to hear from the government again.
Yes, Your Honor. Now that the record is closed, there are exactly 2 types of evidence the jury can rely on. Testimony from witnesses, including testimony about documents, and the exhibit that had been entered into evidence. At no point did any witness say anything about the amount of people that had rented the car afterwards, and we did not enter Exhibit 10 into evidence. Therefore, the parts of Exhibit 10 that no witness talked about are not in evidence, and defense cannot use them in their closing argument.
Your Honor, on those grounds, I would move to strike the portion of testimonies offered by the state's own witness that's based on the foundation of this document if it's opposing counsel's contention that this document not being entered in evidence means that its contents are inadmissible.
Response to that, Your Honor?
Yes.
Your Honor, our witness testified about that. It is on the record and therefore is in evidence. Opposing counsel could have cross-examined on this and it would have been in the record, but because they chose not to, they can't use facts that didn't come up in the case in closing argument.
Your Honor, may I be heard on those grounds?
Yes.
If opposing counsel's issue with this document is its inadmissibility, they can't have it both ways. What's good for the goose is good for the gander. If this document was inadmissible, that doesn't necessarily make their state witness's testimony admissible just because they quoted from this document. At that point, I would reserve my hearsay objection for review.
Response, Your Honor?
Yes.
Your Honor, we're not saying the document is inadmissible. We're saying the defense chose not to admit it. The defense also chose not to object to any part of our characterization of it. Everything that we said came onto the record without objection, but the testimony in defense's closing argument never came onto the record and is not in evidence.
Final response, Your Honor.
Yes, fine.
It seems like the crux of opposing counsel's argument is that without this document being in evidence, referring to its contents in my closing argument is inadmissible. But Your Honor, I would argue that opposing counsel did the same as this same document, which wasn't entered into evidence by the state either, was the foundation of their testimony and some of the testimony brought out on their closing examination about how these jumper cables ended up in court.
Right, so I'm going to ask the government, was your witness relying on information from this document in the marshal who testified? Were they, because they did not, this particular marshal did not prepare this letter. And so it was a letter to the marshal. Now, was your witness relying on information from this letter when the witness testified?
Yes, Your Honor. The witness specifically mentioned a single line from this document.
Okay.
And that came in without objection from opposing counsel.
I understand. So the court is going to rule, I believe the way a court would rule, and I understand that this actual exhibit did not come into evidence. However, I'm going to say, given that the government did have its witness rely on it, no one is saying that this is not admissible. However, so I'm going to allow the defense to have included this information in your closing argument. However, I believe that we should correct the record because I believe it was only rented 2 times, not 3 times afterwards.
Yes, Your Honor.
Okay, so I will instruct the jury that, and this all would have been a sidebar, and the judge would just instruct the jury that the evidence is that the car was rented 2 times afterwards, okay? So that's how the court rules.
Yes, Your Honor.
Yes.
Yes, Your Honor.
And with that, rebuttal from the government?
Yes.
May I proceed?
Yes, you may.
Ms. Shepard, or my apologies, Ms. Campbell has got up here and asked you to have 3 questions about this case. Did the defendant have a motive? Did they have access to the murder weapon? And were they there on the night of the murder? So let's walk through the defendant's tracks and see how each of those questions has already been answered. First, did the defendant have motive? Well, members of the jury, today you heard, on the record, testimony from an FBI agent who specializes in investigating crimes about organized crime. And they told you, whenever someone testifies against a crime family, well, that crime family has no choice but to kill that person in revenge. You heard today from that same report that the defendant is the head of one of the largest crime families on the East Coast. So absolutely, the defendant had motive to kill Barry Capela. Second, did the defendant have access? Well, you just heard about that too. How the defendant had a rental car with the same type of jumper cables, and that afterwards, those jumper cables went missing from that car. So yes, the defendant had access to the murder weapon. And finally, did the defendant have the ability to find the witness's house? Well, this one's not that hard to answer either, members of the jury, because we know that the defendant was right outside the place where the victim worked. And unfortunately, the place where the victim worked was named after the victim. So the defendant had the victim's new name. And once you have someone's name, in 2021, it wasn't that hard to find where that person lived. So yes, the defendant had the motive to kill Barry Capela, he had access to the murder weapon, and he had every ability to find out where the victim lived. By walking through the defendant's tracks, we can see that there is no reasonable explanation besides the defendant at the victim's house with these jumper cables being the reason that Barry Capela isn't here today. Find the defendant guilty. Thank you.
Thank you, counsel. Is there anything else from either party?
No, Your Honor.
No, Your Honor.
Okay, so trial's all done? Fantastic. You guys were great. So I'm not sure exactly